Data Agenda Datenschutz Podcast, der Expertentalk mit Professor Dr. Rolf Schwartmann.
Status of the AI Act in October 2023 on the home stretch of facing another run. Welcome to Data Agenda Datenschutz Podcast. Today is October 11th, 2023, and I'm happy to meet Kai Zenner for this Data Agenda Datenschutz podcast. And Kai is the office manager of EVP, a rapporteur of AI regulation, Axel Voss. And our topic today is AI regulation with a headline that is admittedly very to the point. AI Act in October 2023, home stretch or new attempt. Hi Kai, I catched you between negotiation meetings. How are you doing?
Thank you for the invitation. And yeah, as you said, it's very busy right now. We are having constant technical meetings and also informal meetings. After our sessions, I'm running to the Spanish presidency, and we will start pre-discussing exclusive competences of the Euro Committee. And yeah, at the moment, there's still a push for closing as soon as possible, but we still have a lot of topics on our plate. So it's a very tight schedule. Similar to the heading of our podcast, it's indeed at the moment rather unclear how likely it is that we are successful in the end and able to adopt it in time.
Okay, what do you think? When do you know more? Maybe in November or something like that. The AI Act will happen this year, or what do you think?
Yeah, probably. So the last chance for a political agreement this year is very likely the 6th of December. We need to finish on the 6th of December in order to publish the AI Act in the official EU journal, where all the new laws are published, and only after this step the law is really entering into force. If we want to do that before the European election in June next year, taking into account that even after a political agreement on the AI Act, it still needs to be voted on in the parliament, in the council. There need to be lawyer linguists going through the text or over the text. There need to be translations in all the different languages. This takes time, and this time we will need probably from January next year until May or something like this. So again, we really have now a short period of time to close all the different open points that are still on the table. And this is actually now 6 to 8 weeks. If we are managing to do that, no one really knows right now. But the closer we are coming to the 6th of December, I would say the better our gut feeling is becoming. So to your question, probably in mid-November, I already can indicate, okay, there is still too much on our plate, unsolved, still open. We will not manage the 6th of December, or I'm more optimist in the mid of December due to our success in the last weeks. Then I can maybe say, okay, look, now we have identified the last 3-4 points, and those we will also then be able to prepare for the 6th of December. Because maybe for our listeners that are not so close into European politics, on those political trilogue meetings, the let's say, top level of policy makers, they are not discussing about every detail of the AI Act. So it's really more on the broader things. So those meetings need to be prepared to a large level of detail or high level of detail in order for this top level of policymakers to make the final decisions.
Okay, thank you for this estimation on the timetable. Let's get into some content issues. If you had to name now the current best list of central topics and the trilogue on the AI Act, what would it be and what is it about?
Yeah, so I would mention 4 topics here, but just to also shortly state the status quo. So we made a lot of progress. We approved a lot of so-called batches, so articles in the AI Act, even on a political level. So meaning that those are concluded. We don't need to discuss them anymore. But within those approved batches, there are a lot of parked paragraphs, sentence, but even articles, meaning that even those 4 topics that I'm currently or that I'm now telling you about, there are still a lot of additional minor and not so minor points that also need to be discussed. From the 4, let's say, big things that are still on the plate, I need to mention at first the prohibitions. Article 5. So what kind of AI systems we do not want to see in the European Union in the future? For example, social scoring, for example, facial recognition, and so on, where we have this problem that member states and their especially law enforcement authorities would like to use AI technologies to catch the bad guys, to prevent terrorist attacks, and so on, while especially the left-wing political groups are highly concerned about let's say problems for our fundamental rights, civil liberties, and so on. And they would like to really ban it to a maximum extent. And to find a middle ground between those 2 extreme positions will be very, very tricky. And the second block that is still open is high risk classification. So in this risk pyramid, I was just talking about the first layer, the prohibitions, and now the second layer would be high risk AI systems. And there, again, similar to the prohibitions, it really matters what the details are saying. It matters, for example, what exactly should be classified as high risk in the employment sector. Is it already, if an AI system is just preparing let's say applications for a new job, and then let the human being make the final decision which person that applied for a job gets a job in the end, or is it only high risk if this whole process would be fully automated and the AI system also takes the final decision? What should be those high-risk use cases? All those points are currently being discussed, and it's also very much open where we will land in the end. The third block is governance. How much should be centralized in the end? How powerful should be the European Commission and the new EU office? How much power they should have in enforcing the AI Act, meaning that member states, national competent authorities would also lose certain parts of their sovereignty. Again, a very tricky topic, because as you can imagine, member states do not like to transfer their national power towards the European Union. But based on our experience with the GDPR enforcement, where, for example, in member states like Ireland or Luxembourg, there were problems to enforce the GDPR, maybe it's necessary. Again, a very tricky issue on our table, because I would say there are valid points on both sides. And the fourth point, which is currently rather tricky, and where we actually do not really know yet in which direction we will head is foundation model, general purpose AI systems, and the whole question of AI value chain. The Council of the European Union made some proposals focusing more on general purpose AI systems and information sharing along the value chain. This was also super important for the European Parliament, but the Parliament was going even further upstream in the AI value chain and singling out those powerful and very potentially market-dominating foundation models like OpenAI's ChatGPT, and trying to make sure that those foundation models are fulfilling certain minimum criteria. Again, where we land in our final text is currently really, really unclear. It will be highly likely a mix of both. I would say there are so many different opinions on this topic specifically that everyone is a little bit lost how to regulate it best. Those 4 points, I would say, are the most crucial ones at the moment.
Okay, thanks a lot for these 4 tricky, crucial points. And let's switch to the challenges for companies. For example, mid-size companies. They want to use AI and they want to prepare them for regulation, and the business community has high expectations and hopes for good regulation. A lot depends on it. Is there anything that companies can pay attention to right now, you could say?
Yeah. So right now, it's really important that they are aware that something is coming. What we saw with the GDPR, that many companies in 2018, when the law became applicable, were kind of shocked that there is a lot that they now need to do, that probably GDPR is much more enforced than previous data protection regulations. This should not happen again. So companies should use their time to prepare for the AI Act, but at the same time, they should also be a bit more relaxed. If we are currently talking with some elements of the business sector, there is the impression that some companies believe that they need to immediately comply with the whole AI Act, which is not true. There are transition periods. Again, we don't even know if we are concluding the AI Act in the next month. So companies do have some years, maybe 2.5 years to prepare. But again, learning from the GDPR experience, they should really use those 2.5 years wisely and prepare in time and start their preparation now. How to do that? Well, I would say it's rather simple, or there are only a few points where they should fully engage right now. And this is, first of all, harmonized standards. The AI Act is heavily based on technical harmonized standards that are developed by CENELEC, the European standardization organizations. And those harmonized standards will have a huge effect based on Article 40 of the AI Act, which is giving companies a presumption of conformity, meaning that a company that is developing their AI system based on this harmonized standards, taking it fully into account, is automatically seen as fully compliant with the AI Act, making compliance rather easy compared to the GDPR, where this part was missing, which means that it's very tricky for companies to prove that they are fully compliant. But this also means that those standards really need to be on point. They need to be excellent. They need to be very comprehensive and so on. If now European companies, and especially smaller companies, do allow that standardization is dominated by big corporations, especially by big US or Chinese corporations, important points from a European perspective are maybe not mirrored by those harmonized standards, which would have a very negative effect for our companies. So again, this point super important for all the business sector right now to please engage with standardization processes. In Germany, it would be DIN. Even the UK is still in CEN-CENELEC. So if you are a UK company, you can go to BSI, but all member states have a national standardization body. Please engage here, at least go to the trade associations like in Germany, BDI or Bitkom or ZVE or whoever, because at least the trade associations should transfer your points in the standardization bodies. The second point, or my second advice for companies right now, is to engage with national competent authorities, those supervisory authorities in the future that will implement and enforce the AI Act. They are also preparing already to do so. They will in the future also write guidelines and guidance, and they are often lacking the expertise and the experience, especially when it's coming to unique topics like, for example, again, foundation models. We have only two companies right now, Mistral and Aleph Alpha, in the European Union that are leading on this. And I would say no national competent authority has any experts on those topics right now across the European Union. So if you are one of those companies, or if you are a researcher in a university from Europe, you have a very, very good chance to start a very close dialogue with the public authority, because the public authority needs to improve their knowledge. They need to learn a lot about what is happening on the market and so on. This, again, means it's really important to engage basically from now on with the national competent authority and share information, but also learn from them. You know already, or they will be able to tell you already what could become important in the future, how they understand certain obligations in the AI Act, which means then for the company that is engaging early, they would know much earlier than other companies what is coming. So it's really a dialogue, and both sides can learn a lot about it. I would say those two things are the most important issues right now. And maybe one point that maybe we should also mention here: the AI Act is just one element of a kind of flood of digital legislation that was coming now with this European Commission. So there's the Digital Services Act, the Digital Market Act, there's the Cyber Resilience Act, and so on. Unfortunately, companies need to deal with all those laws, and all those laws are interconnected. They are overlapping. They are having some synergies, and so on and so on. So companies really need to invest in compliance, but also in better understanding of legal challenges, of legal responsibilities, and not have one person that is only working on the AI Act and another person who is only working on, I don't know, cybersecurity. It's all interconnected nowadays. So also internally, companies, I think, should make sure that European digital policies, national digital policies, international standards, or other things that are important for your business are being seen by the same people, that in your company, the compliance department is very closely connected with the policy department and so on, because even a big company like Siemens will only be able to stay compliant with the existing law if all the different elements within the company are working together.
Okay, thank you, Kai, for this point of view to the challenges for companies. Well, this was a brief interview, 3 questions, 3 answers. thank you very much, dear Kai, for your precious time and the valuable insights. You have to hurry to an informal meeting with some Spanish colleagues. And so I once again say thank you very much for your time, and thanks to all listeners, and hear you the next time in the Data Agenda podcast. Goodbye.
Das war der Data Agenda Datenschutz Podcast, der Expertentalk mit Professor Dr. Rolf Schwartmann.